Okay, so now that you've learned about the foreclosure process, we've defined the terms, talked about the documents used in foreclosures. We've also talked about the foreclosure process here in Ohio, and talked about predatory lending. We're next going to move forward and talk about mortgage securitization and define what that means. 30 years ago, if you would have gone into a bank, executed a mortgage, that same bank would have remained the owner of your mortgage until the mortgage was repaid. This is no longer the case today. Now, the original bank that you went to, executed the mortgage document, they may no longer even own the mortgage. Not only may that bank not be the actual owner of your mortgage today, but the mortgage could have been sold without your knowledge. And most of your loans were sold on Wall Street, and that process of the selling of your loan on Wall Street is called securitization. In many cases, your loan was sold not once, not twice, not even three times, but your loan was sold over and over and over again without you even knowing that the bank sold your loan. The New York Times reported that some loans were traded as many as 600 times while the bank profited from the selling of your loan. The University of Iowa found that 40% of banks foreclosing on borrowers cannot even prove that they actually own the loan. So 40% of the banks that are foreclosing on homes, taking these homes back from the rightful owner, haven't even proved that they actually own the loan. And this lack of proof of ownership can prevent the foreclosure process. A federal judge in Cleveland dismissed 14 cases because the trustee was unable to prove actual ownership of the note. During this past year, similar foreclosure cases have been dismissed based on the same reason, the bank's lack of proof that they own the note. So what's the climate like here in Ohio? Let's now talk about the Ohio foreclosure climate. In October of 2010, the Chicago Tribune stated that allegations of possible mortgage fraud against financial giants such as GMAC, JP Morgan Chase, and Bank of America read like a corporate thriller. Forged documents, fake social security numbers, phantom titles, disappearing paper trails, robo-signers, and mortgages sliced and diced so many times that no one actually knows who owns these mortgages. On March 8th of 2011, the New York Times said that all 50 state attorney generals, as well as a host of federal agencies, are pushing for settlement over investigation into foreclosure abuses by major mortgage servicers that could cost the industry $20 billion or more. The Plain Dealer in October of 2010 said that the Ohio Attorney General, Richard Cordray, sued GMAC Mortgage, alleging that the company filed false documents in hundreds of Ohio foreclosure cases. Our former Attorney General stressed that other big banks may be guilty of this same practice. So now the fight for foreclosures, now that we know that these robo-signers exist, that there are fake social security numbers being used on these documents, that mortgages are being sliced and diced, that the notes are being sold without you even knowing that your mortgage was sold, what are we going to do to fight against this foreclosure process here in Ohio? First, we need to talk about why it's important to have the original paperwork when we go to court. The original promissory note is the live negotiable instrument. It's like a cashier's check from a bank. This is the IOU that you, as the borrower, signed when you executed your mortgage. Lenders may try to foreclose with just a copy of the note, but they don't have the actual original promissory note that you signed. If a lawsuit or foreclosure action isn't challenged, then the lender, like we talked about earlier, they'll receive a default judgment. They automatically receive judgment against you simply because you didn't put up a fight. This is like going to a bank with a copy of the cashier's check and expecting for it to be cashed. Now, doesn't that sound absurd? If you go to a bank, the teller wants you to have the original cashier's check, not just a copy of the check to be able to present and say, here, I want money based on a copy. So we're fighting these foreclosures saying, give us the original documentation. A copy will not suffice, not to take someone's home. The assignment of a mortgage from one holder to another is an exacting process that requires proper assignment. Many cases of improper and fraudulent assignment of mortgages have been discovered, which is another reason why we want the original paperwork. We don't want to risk that the paperwork being presented in court is fraudulent. We want to know by having the originals and know that we have the original documents that are being demonstrated, that are being produced in court. A lender must prove that they have the right to foreclose. A lender must prove that they have the right to foreclose, and this is called standing. In order to be able to file your lawsuit in court, in order to be able to receive judgment in court, you must prove that you have standing, that you're the one who's the actual owner. If you're not the owner, then you haven't suffered any harm. So we want the lender to prove that they're the actual owner. How do we want them to prove that? By giving us the proper paperwork, by giving us the original documentation. Officials disagree on penalties for the mortgage mess. On March 2nd of 2011, the New York Times quoted Bank of America's argument. Bank of America said that it was unfair that homeowners who are delinquent or underwater but can point to specific errors of their case was unfair. Now, simply because you may have fallen behind on your payments, your house could be underwater due to the climate here, the Bank of America said that it's unfair that you can point to these legalities and say that the mortgage process, the foreclosure process rather, should come to a halt. What type of legal defenses do you have? The legal defenses that you have to come to your aid, one, you already know that the foreclosure complaint has been filed against you. What can you do next? You can retain an attorney who is experienced in defending foreclosure and has knowledge and expertise in this area. You can retain such an attorney to represent you. Now, this attorney should perform a forensic audit of your loan to look for the violations that we talked about earlier, to see if any of these violations, we told you earlier, we're finding these violations in 8 out of 10 cases. So you want an attorney who's going to be able to perform a forensic audit of your loan. Also, the attorney should be able to conduct an extensive foreclosure document review to look for errors and to look for violations. You want an attorney who's going to ask for the original documentation and say that a copy of the documents will not suffice.